Welcome to my channel. 1. Zanu PF contests High Court verdict barring them from forcing pupils and teachers to attend rallies. Zanu PF has appealed to the Supreme Court against a recent High Court judgment barring it from forcing pupils and teachers to attend political rallies, saying the decision was made without any proof of such infractions. The High Court last week interdicted Zanu PF from forcing or asking pupils and teachers to attend political rallies. The ruling party was also barred from using school property, including structures and buses, for political activities following an application by the Amalgamated Rural Teachers Union of Zimbabwe. The order was granted despite opposing papers filed by Zanu PF challenging the union to prove that Zanu PF was indeed guilty of such violations. On Wednesday, Zanu PF lawyer Mr. Nikhil Mushangwa of Mushangwa and Partners filed a notice of appeal at the Supreme Court. The ruling party, in the grounds of appeal, argued that the judge erred by granting the order based on unsubstantiated allegations against Zanu PF. This is despite widespread photographic evidence showing that the ruling party is indeed forcing pupils to Zanu PF rallies. Nahanda Radio Middle Off Story. The learned judge in the court a quo misdirected himself by granting the interdict against the appellant in circumstances where there was no evidence linking same with the alleged infractions other than an erroneous construction that conflates the party and the state, reads the notice of appeal. During the High Court proceedings, Mr. Mushangwa opposed the application, saying there was not a shred of evidence that Zanu PF commandeered school buses. He also argued that the teachers' union failed to prove that teachers and pupils were forced by the ruling party to attend rallies. Mr. Mushangwa argued that the union was confusing the government and Zanu PF, which is a mere political outfit, in framing the allegations. The applicant did not establish a well-grounded apprehension of irreparable harm or injury actually committed, he said. There is no single piece of document, evidence or sworn testimony that connects the first respondent with the attendance of children at its rallies. What appears seems to be a tenuous attempt to conflate the first respondent, Zanu PF, a political party which also happens to be the ruling party, and the government, which is a separate entity that operates educational matters through the second respondent, Minister of Primary and Secondary Education. The court also relied on a human rights report which was more than a year old, which was compiled during the tenure of former President Robert Mugabe. In the new dispensation, the lawyer argued, all the allegations leveled against Zanu PF were unsubstantiated and baseless. However, in this matter the facts are distinguishable, as this is a new dispensation where there is a new way of doing things, said the lawyer. Thank for watching. Please, subscribe and share. See you again.